Hello, everyone. It's nice to be virtually joining this conference. I'm speaking from Treaty 6 territory and the homeland of the Métis. I've been living here for about 5 years now, and I work as an assistant professor in Indigenous Studies and Women's and Gender Studies at the University of Saskatchewan. I'm a white settler who was raised in what is Haudenosaunee and Anishinaabe territories in a region in southern Ontario that falls within the Haldimand Tract, a treaty area with outstanding land claims regarding Haudenosaunee rights. My presentation briefly examines how Indigenous people deemed guilty of HIV non-disclosure are represented and talked about in cases going through the Canadian criminal justice system. As many people at this conference will know, there are not specific HIV non-disclosure laws in Canada. Instead, this legal issue is dealt with through existing criminal code charges, with aggravated sexual assault being among the most widely used charge within recent history. Many people living with HIV, advocates, researchers, and legal practitioners have raised concerns that the application of sexual assault charges is problematic and that the standards for defining risk have been too strict and that they create fear around disclosure. In 2017, the Department of Justice acknowledged that the application of law in this area is harsh and out of line with medical standards. In 2018, the Attorney General issued a directive to Crown prosecutors to not use sexual offenses for non-disclosure and to generally accept just a low viral load or just condom use as sufficient for mitigating risk. As the HIV Legal Network commented in 2019, while this announcement was a positive step against HIV criminalization, concerns remain that further change is still needed, that it is up to each province to take up this federal directive, and that there is still confusion about if this change will be implemented. There are outstanding concerns as well that these potential changes will not mean that criminalization will stop against people who are often multiply stigmatized, targeted, and chronically disbelieved in the justice system. Indigenous people, for example, have distinct experiences with HIV, facing racially fueled stigma alongside high rates of HIV in Indigenous communities, which is too often not examined with settler colonialism in mind. Indigenous people also have distinct experiences with the Canadian legal system and having to deal with the imposition of this settler legal system at the expense of Indigenous people's own legal sovereignty. HIV criminalization should be critically challenged in all of its forms, and it's vital to take an intersectional approach, which, as I focus on here, includes taking a decolonial approach. So this research, it's based on 5 cases, which represents the public judgments available in cases where it's stated that the accused is Indigenous and where the circumstances in the cases related to non-disclosure are in the context of otherwise consensual sex. The cases were analyzed using critical discourse analysis, which examines discourse as reflecting, but also producing social relations. My approach in this research brings critical discourse analysis into conversation with Indigenous feminist legal theory to encourage an intersectional, anti-colonial, gendered approach for examining representations of indigeneity and law, which necessitates understanding that Canadian law is not the only form of law on these lands. In vivo qualitative software was used to code the judgments. It is noteworthy that the data has also been analyzed for silences and what is not said and what therefore could not be coded. The intent with this research is not to name or identify those who have been deemed guilty. Rather, the focus is on how indigeneity, HIV, and law are talked about in these decisions. In the cases, Indigenous people living with HIV are treated as having risky bodies, and that representation operates alongside existing settler colonial tropes in which Indigenous people have long been treated by settlers as having risky bodies, as having sexuality that is deviant, as being individually irresponsible with their health, and Western medicine and settler laws are presented as that which will then protect others from Indigenous people and which will protect Indigenous people from themselves. In 1999, the Supreme Court of Canada provided its decision in the Gladue case, which stated that the indigeneity of those being sentenced through the criminal code needs to be considered in an effort to address problems with the overrepresentation of Indigenous people in Canadian prisons. The application of Gladue sentencing principles, as many have highlighted, has had many flaws and has not worked to address the issue of overrepresentation. These cases about HIV non-disclosure are no exception, and while Gladue is noted in each of the judgments in varying degrees of attention, it is engaged with in many troubling ways. For one of the defendants, it is noted that they are Indigenous, but then the judge and each of the parties' lawyers agree that it has no relevance to the case. In another case, it is concluded by the judge that the defendant's, quote, status as an Aboriginal should have little bearing, end quote, on the sentence. The logic in the reasoning provided in this latter case is that applying Gladue means examining intergenerational trauma, which means examining addictions. The defendant was not engaged in drug or alcohol use during most of the relationship, therefore it's reasoned that Gladue is not relevant here. The defendant then can only be read as Indigenous when actively playing out an addiction related to intergenerational trauma. Otherwise, they are not afforded an analysis of settler colonialism. Moreover, in that case, it is reasoned that Gladue sentencing should not apply because of the seriousness of the crime. Yet if the common convictions related to HIV non-disclosure are aggravated sexual assault, and aggravated assault, and if Indigenous people are regularly treated more punitively through the legal system, then how could there be space for Gladue? It has since been clarified in R.V. Ipili that Gladue sentencing needs to apply in cases involving serious crimes, but it is still difficult to see how Gladue will be meaningfully applied when judges regularly focus on HIV non-disclosure in ways that emphasize maximum risk and harm over nuanced analyses that include direct examination of structural issues. The focus on intergenerational family issues, addictions, and other traumas in the cases are separated from the language of racism and settler colonialism, which are never uttered, and the discussion in the judgments instead work to reproduce racist tropes of Aboriginal dysfunction. Gladue sentencing is also approached in a way that is gender neutral, therefore denying intersectional analyses of the defendant's experiences and denying the intimate and structured connections between settler colonialism and heteropatriarchy. When examining how law is talked about, it is portrayed as a site of objectivity and rationality, even in the face of the confusing and unclear use of law and precedents related to HIV non-disclosure. This highly complex area of law is oversimplified, and these approaches and precedents then reinforce and reproduce one another. There's a heavy emphasis in the judgments on denunciation and deterrence, which would not be unusual in a judgment, but those discourses about serving justice and promoting the broader social interests sit alongside deeply entrenched settler colonial narratives about containing and controlling Indigenous bodies. These representations of Indigenous people as unruly and as a risk to the settler public is a key part of the narratives that attempt to justify and rationalize the incarceration of Indigenous people through settler institutions. Nowhere in the cases is it acknowledged that the Canadian legal system is a core mechanism of settler colonialism, that it asserts itself as having governance over these lands, and that it declares itself as the final decision maker regarding all things to do with law. There is a significant silence then in each of the cases regarding Indigenous laws. Occasionally, Indigenous cultures are mentioned, or Indigenous programming through correctional services is noted, but that is not the same thing as acknowledging that Indigenous peoples have their own legal orders, principles, and legal practices, and that Indigenous nations have inherent rights to legal self-determination and legal agency. It is vital in future discussions about HIV non-disclosure and when people are advocating for law reform or alternative approaches to the use of criminal law that the entanglement of structural issues be addressed and challenged, and that a decolonial approach be applied wherein Canadian laws and the Canadian healthcare system are not naturalized as the only forms of governance and well-being on these lands. Thank you for listening.